would like to acknowledge the traditional owners, acknowledge and celebrate the traditional owners, the Nanawan and Ngambri people, on whose lands we meet, and we pay respects to the elders past, present, and emerging. We also acknowledge that land was never ceded. So welcome to the panel on challenges of cross-border displacement. I'm Ramitesh Kant from Fiji. It's a privilege to be chairing this panel. And the esteemed panelists, who are activists and legal scholars, will endeavor to delve into the political, environmental, legal, and cultural challenges faced by two communities that were dispossessed and relocated from the Ellice and Gilbert Islands to Fiji, in Rabi, and in Solomon Islands. And I think the keynote speaker set the stage up, talking about healing the land and people's connections to land, and the central importance land plays in Pacific communities and their sort of their notion of who they are and where they belong. So we have with us Professor Katerina Teaiwa of Kiribati Rabi descent, also African American. She's an activist, scholar, practitioner scholar, who delves into the intersection of art and activism with academia. And she's done a lot of work around people from Rabi, consuming Oceania, consuming Banaba was her penultimate sort of research. She's also the vice president of the Australian Association for Pacific Studies. We have Ray from Banaba. He's a young human rights defender who also walks around highlighting and amplifying the voices of Banabans in the context of, from Fiji, looking at the relationship that Banabans have with Fiji, but also with Kiribati, and the tensions the intergenerational tensions that come up. And he's set up a Banaban Human Rights Defenders Network that works with young Banabans, advocating for, and he's also a climate change warrior, Pacific climate change warriors. We have Professor Rebecca Monson, who'll go third. She works at the College of Law, works at the intersection of gender, property law, property rights, and if I can pronounce this word, legal pluralism. I got it. And we have Dr. Anna Zizek, also an academic practitioner, who's done her PhD on foreign judges in the Pacific, but now is working with International IDEA as the Constitutional Building Officer for the Asia-Pacific region. So without further ado, I'll hand over to Professor Katerina.
Thank you so much, Ramitesh. Kamna Maori and Nisambula Vinaka, everyone. It's really great to have this opportunity to present to you today. And I also want to acknowledge that there's a very awesome panel on AUKUS happening simultaneously that I'm sure many of us, including our panel, would have liked to be listening to and participating in. But thank you to everyone who came to our panel instead. Just acknowledging the traditional owners of the very, very unceded lands that we live and work on, the Ngunnawal and Ngambri peoples in this region. And I want to make that acknowledgement in a way that doesn't tokenize, that process either, because we are talking today about the importance of both land and people and the connections between land and people, particularly in the context of displacement. So when we make these acknowledgements of traditional owners and people who've belonged to land for thousands of years, we in the Pacific hope we're always taking that very seriously as a statement of solidarity and recognition of what has been lost and what has often been taken by force from Indigenous peoples. So we're going to have a dialogue today between a few of us, and I feel like this might be the first time that Banabans and law folks have come together to actually talk seriously about these issues, and I don't understand why we haven't done that before, and it's really long overdue. I mean, Banabans have sued a lot of different people over the years for what has happened to their island, but I think we've come to the point where people have been working on Banaban histories, people have been working on histories of displacement of Gilbertese to the Solomon Islands and other places, and those working in legal spaces on land, property, constitutions, citizenship issues, human rights, now really need to work more closely together, because the displacement that we're talking about has really, really serious long-term impacts on communities, on cultures, on societies, on generations of islanders. I guess the other reason why this topic might be quite relevant is there's a lot of talk about expected environmental displacement in the Pacific from climate change and for, many other reasons, but particularly climate change. And one of our arguments is that you can't plan for environmental displacement if you don't understand what's already happened in the past. If you don't understand what communities that have been, the ones we're talking about, lifted wholesale from their indigenous lands and moved to completely different islands, completely different cultural, historical, political contexts, and then expected to somehow get on with life. That is really, really difficult, and we need to understand what happens to people when you move people like that. So for a long time, I'm going to be giving a bit of a historical context, and then I will hand it over to Ray, who will talk about what's happening on the ground, especially what young people are trying to do, and a few good elders out there. I'll hand it over to Ray, and then both Rebecca and Anna will make these connections to other displacement, but also to the legal and constitutional issues that kind of unfold from this. My research for a very long time has been trying to track the displacement of both people and land. So we heard a wonderful keynote this morning that really made the point that I've been trying to make for 25 years to our communities and our colleagues, which is that land and people are not separate. Usually Pacific women know this really, really well. But history, colonialism, Christianity, and patriarchy have done everything in their power, not to mention capitalism and globalization and everything else, to wrench apart this relationship between people and the land, but particularly women as holders and keepers of that land, which is about security as well. Not the kind of security we hear about in the context of Indo-Pacific geopolitical rivalry, real security, safety, health, well-being, good livelihoods, all of those sorts of things. So wrenching apart the relationship between people and land has serious long-term consequences. And that's not even with something like extractive mining. Right? There's a lot of discussion in the Pacific right now about all kinds of mining that people are hoping to do, including deep sea mining, and people need to understand the consequences of that. This is what happened to our island. So it is a 6 square kilometer island right in the middle of the Pacific, the very, very middle of the Pacific. Often people think about the Pacific from the edges. Everybody thinks about where all the populations are. So it might be the Southwest Pacific, might be the Northeast Pacific, might be the Northwest Pacific. There isn't a huge amount of thinking about history or regionalism from the very middle of the Pacific. The archives that I've been studying, which are collections in the National Archives of Australia and also the Bar Smith Library at the University of Adelaide, have this vision of Pacific history that starts from the middle and spreads out from there. And that's because of phosphate mining on Banaba, which was a real hub of the Pacific from 1900 to 1980. So this map tracks the movement of land. It tracks the movement of people. It tracks the movement of labor associated with the mining as well, which involved Gilbertese mining laborers, Tuvaluan mining laborers, Chinese, Japanese, Australian, New Zealander, British laborers, lots of different communities worked on Banaba. And then the land itself, in the form of crushed and processed what would become superphosphate fertilizer, also moved away. So we're talking about double displacement of both the land and both the people, which sets up a really interesting conundrum if you're indigenous to a place. It's a double displacement. So this is 80 years of mining. 80 years of mining. And I was in a workshop yesterday which focused on peace and environmental degradation. And one of the responses to this discussion of Banaba was, oh, but you guys got a trust fund. And it kind of like hit me all of a sudden. Those of you from my generation or older would have heard these stories about Nauruans and Banabans and how they got rich from phosphate. And the establishment of trust funds associated with that mining gave this perception that Banabans were rich, and whatever bad things happened to them afterwards was a consequence of not managing those trust funds very well. So one of my arguments is money does not replace land. There is no equivalence between money and land. When you mine out land, when you destroy the freshwater resources associated with that land, that is hundreds of years of consequences that money cannot substitute for. Plus, when you throw money at people, and in this case, it wasn't a huge amount of money for Banabans, you foster a sense of, you bring along con artists, there's corruption, there's mismanagement of funds. There are consequences for throwing money at people without training in financial literacies and a whole bunch of other things. Banabans always knew that there was a problem for them when their land was dug up and shipped away. Not just land, but trees. All the pandanus and coconut trees had to be cleared before the land could be blasted and the rocks could be shipped. So this was a problem for Banabans, especially Banaban women who really didn't like the extraction of their land. And Banabans have always been protesting the processes and forces of extraction right from the beginning. So there is a history of activism amongst our people, which some in the present leadership like to conveniently forget. It set up a situation where Banabans live between two lands in two different nation states, Fiji and Kiribati. The company that extracted all the land belonged to Australia, New Zealand, and Great Britain. It belonged to their governments. When the mining ended and the people were displaced to Fiji, none of these countries took responsibility for what happened to Banaba. They washed their hands of it. They handed a Banaba over to Kiribati and said, your problem now. And Kiribati, which had benefited greatly from the mining through the taxation of the mining, was not about to hear anything in terms of what Banabans needed. So this has caused Banabans to fall through the cracks. All cracks, legal, social, political, infrastructural, you name it, development, they've fallen through the cracks, and no country wants to take responsibility for what's happened to them. So again, the talk this morning about responsibility, accountability, truth-telling around what's happened historically was really important and resonated. So you have families and communities kind of living between two different countries with two different sets of legal, political, educational possibilities, and almost never succeeding or being advantaged by either. Banaba itself was left as a desiccated, decomposing industry, like just a dead mining town in the middle of the Pacific after 80 years of mining. It is now an island without fresh drinking water, something that had sustained people on the island for 2,000 years, always facing periods of drought where things were difficult, but people worked it out. They had strategies for resilience and survival that helped them. The mining made that so much worse. It's also a land without food often because there aren't regular services there. Supply is really difficult. And again, the Kiribati government doesn't necessarily look after all the needs of the community on Banaba. So both the islands, kind of struggle with these issues. In the meantime, the story about what happened to Banaba folks like me and others continue to try to tell this story to wider audiences so that they don't forget that this is a regional story, it's a global story, it's something that we can still learn from, but there are still reparations owed and healing that has to take place. So I do my work not just in text and writing, teaching, research, but I also put on multimedia exhibitions to tell this story to wider audiences. And this is one of my exhibitions where I staged it near the phosphate mining processing plant in New Zealand that had been mining our land for thousands of years. It felt like thousands of years, but for decades. So that's to, kind of bring the story together with the industry. This is still a worldwide problem, and so this phosphate mining going on all around the world is a problem for a lot of indigenous communities, so it's not just us. I'm going to try to wrap this up quickly, but there is still an interest in mining on Banaba, and some of our leaders are quite interested in that, remining the phosphate, which is still valuable, particularly in the green energy sector, for example. It's not just about agriculture anymore, but phosphate and the phosphoric acid that comes from phosphate is still quite valuable. So there's all of these potential partners kind of sniffing around Banaba and saying, oh, you could do this, you could do that, $800,000, we see on pieces of paper, and that looks attractive to some leaders. So this is a problem, and Ray and others have protested about this, and, if you've been following the story in the newspapers, we managed to stop one particular company. I don't know how fully we've stopped them, but they've paused their interest for a while. So there's a few of us who work with community on these sorts of issues. Ray's going to talk a little bit more about what they've been doing, but sorry, I just, there's some slides of mine missing. Okay. I know what's happened. You brought up the old one again that had been loaded on this computer. I'm so sorry. I will hand it over now to Ray Baintes, but our slides are not there. Yeah, so, yeah. That's the one that's open? Okay, all right. Ray, I'm going to hand it over to you now, and Ray's going to talk about some of the legal, human rights, other aspects of it, and while you're doing that, I'll find the right slides.
Oh, good.
Okay.
Thank you, Katerina. Yeah, so I'm based in Rabi most of the time. We are called Banaban Human Rights Defenders Network. It's a project that we started in 2021 as a Rabi Island Community Hub, formulated and driven by the community themselves. But when I came back to Fiji because of COVID, I got stuck in Rabi, and I thought I started make use of my time during COVID. But it was during one of the first month I was in Rabi when the Ministry for Pacific People in New Zealand reached out that they were organizing a Right to Life with Dignity consultation, and for some reasons they picked out my name from from people who are already engaged in the work in New Zealand. But I got to spoke about the right to life with dignity, about our own experiences as a displaced communities, having been in Rabi now for 79 years. But it was this presentation that led the partnership between ourselves and the International Center Advocates Against Discrimination, i-Kiribati, which is a international NGO that provides pro bono support for refugees and climate displaced communities. So one of the work that we did in Rabi in partnership with the Rabi Council of Leaders and the villagers was doing a full consultation on a report that we published later that year called The Displacement and Dispossession of Banaba and the Banabans. But this report was very interesting because a lot of findings came out. Hence why we developed a project arm called the Banaban Human Rights Defenders Network. But the report basically highlighted many of the human rights violations that happened in the process of our forced relocation. So in context, people were shipped forcefully from Banaba 2,000 kilometers away to Rabi, an island they bought. And so I took a lot of interest in that report, and we advanced a partnership with Clifford Chance through ICAD. And Clifford Chance is a legal firm based in the US who does a lot of pro bono support work to support migrants. And so as a result of that request, they developed a research paper on citizenship. So in context, when the Banabans made Rabi home, there was an act called Banabans Settlement Act, and it's enshrined within the Fijian constitution. So we have two sets of act. So basically, the first report looked at many of the UN conventions or governance or other things that's happening in the UN that Fiji and Kiribati has ratified. And some of the discovery was very interesting because that really was the reason why it pushed our work to develop the human right arm of this work, because we can never talk about marginalized communities without understanding those basic human rights elements that went into the work. But as a result of that work, we did an exhibition in Auckland, New Zealand, to shed some light on these, the story of our displacement in an exhibition in silos, in a silos located in the CBD area close to the wharf, to show some of the things that we've been doing. But I guess the current challenge that we have now in regards to the different sets of legislations has been the focus of my work in Fiji, looking at citizenship. Because as displaced communities, right now we're talking about climate mobility and some of the things that we want to have in this framework that will provide some safeguard for our people when they want to move across the borders. But for us Banabans, it has never worked in our context. Like, we've had to come back and revisit many of those legal challenges that pertains to what happened to our relocation to Fiji. So, for example, some of the recent work we've done is trying to contribute to the review that's happening very rapidly in Fiji. So we launched that citizenship handbook, which is a toolkit that provided. So what ICAD did was they also reached out to Kiribati and Fiji, to lawyers that wanted to provide pro bono support to this work. So we secured those lawyers from Kiribati, and we also secured lawyers from Fiji, and they analyzed those legislations within the two countries that has direct links to Banaban citizenship, and that was the product of that work, and we launched it in Rabi last January. So what we have is a translation of the handbook. So basically what we're trying to do is that when any Banaban that comes across from Kiribati to Fiji who wants to seek pathways to be a Fiji citizen, because by right you can be, and it applies for when our people also cross to Kiribati. Before, they had to find their own ways, and they end up using very expensive avenues, paying a lawyer to get that citizenship sorted. So what the book presents is the different pathways in which a Banaban can gain or access citizenship in both countries. So we launched that report, and we also shared with all the communities, and it was available in both Teaiwa and Gilbertese and in English to allow more of our people to understand the processes. So at the Banaban Human Rights Defenders Network in Rabi, we are not lawyers, we are not anything. We just do a lot of talking for our communities on the work that they want us to do for them. What we do is we reach out and find partners. And the last 3 years, we've had at least six volunteers that came into Rabi to do field work as part of their postgrad and masters. And one of our PhD candidate we were very fortunate to have her. She was a lawyer by profession who was looking into this work. So what she did was she also looked at the Banabans Settlement Act. And after the review of that act, she produced about 20 pages of recommendations on what needs to happen with this Colonial Settler Act that needs to be reviewed to make it better shaped in the context, to work in the context where we are right now. So that was one of and I think it's good to also acknowledge that academia plays a very big role in the work that we do as activists on the ground, busy doing the work, but not documenting what we are doing. So they were also very instrumental in the work that we've done so far in Rabi. So right now, our next steps, getting on from here, from all the work that we do on the ground, is having to do some advocacy in Geneva this coming week. And this is to be part of a universal periodic review. So it becomes very expensive for displaced communities when they are moved away from their island, because now they have two sets of laws that they have to be part of that review to ensure that their voices too are included in national processes when discussions are happening, or when they feel that their voices are not included in reforms, national laws, or reform of national laws. So a team of us are traveling to Geneva to do some advocacy around a paper that we've developed together with ICAD to progress this work. And I think we can't separate the fact that Banabans too left, or they were forced to move out of their ancestral home because of environment degradation. And I think that's the confusion when you try and make the link between climate and extractive industries or phosphate mining. But that connection is what I'm trying to say, that, it's environment degradation. And if you've listened to Pacific, or ABC Pacific the last 2 weeks, you would have heard about our perspective on the, our representation or participation in democratic processes. What do we do with communities that were forced to move out of home and are not able to participate in national elections concerning ancestral home where they originate from? And we've done so many other programs in Rabi, like celebrating World Indigenous Day and other fun stuff with the young people, working in communities. In the coming weeks, we're doing a mass training. And we've been trying our best to keep the youth engaged. Because the problem is, I'm the fifth generation Banaban on Rabi. The sixth is like, I don't know, would they even care about Banaban, all the issues that's happening? Because it's likely that they will forget about Banab at some point. And normally the fourth generation, as I've heard from some of our elders, is the last generation that should remember what happened to their ancestors when they came through that process of forced relocation. Yeah, so I'm a proud Fijian by citizen. I'm a proud Kiribati. I've got ancestry to Kiribati from the southern part of Kiribati. And I guess my role really in this climate activism space and human rights is to tell the truth about things that are happening down there in the communities, regardless of whether they are Banaban or from Kiribati or Tuvalu. And I'm heavily engaged in the region as well with some of the youth work that we do on climate mobility. So with those, you can just search up some of the work that we've done in Rabi and in the Pacific on some of this work that we progress. But it's our hope that the lessons learned that we've started documenting and sharing what happened to us could be something that communities of the future that may have to move because of climate change can pick up and learn from what we did. Also, some of the work that we've been doing with Katerina, where our focus maybe on human rights work, is also progressing. Things like repatriation of our ancestors from Australia who are still in the country, and we hope that with the ongoing partnership with some of the people here at ANU, and someone mentioned this morning, like everything good is happening from ANU, and I believe that's the case for us as well, because many of the consultations that's happening in Fiji, we were not invited by national organization. The invitation came out of ANU for us to attend many of these processes. And that took us a lot of interest. We're now following all the conversations that's happening with the current reform of the laws that are being reviewed in Fiji, and trying to seek out help when we can. And, it's just, it's a learning curve for us. We acknowledge when we make mistakes, but we are so blessed that we have a very good network of people who want to help. And I think that's also part of our culture, in the Pacific culture. Don't be shy to ask if you can't do it. There are people always ready to help you. And that has been the principle that I've lived, building movement. You can never do it alone. You have to move with the communities. Thank you.
Afternoon, everyone. I also want to acknowledge that we're on the unceded lands of displaced people here, the Ngunnawal and Ngambri people. These processes are not recent, as some narratives of climate change try to suggest they are, but they're ongoing and part and parcel of colonisation. So I'm going to move to a slightly different case, that of the Gilbertese in Solomon Islands, because it might help us think through some of the questions of law, politics, justice and belonging for a climate-affected future. So the Gilbertese people are also from the Gilbert and Ellice Island colony, and they were relocated to Solomon Islands in the 50s and 60s. But whereas the Banabans were moved onto an entire island in Fiji, the Gilbertese, and they were legally allocated the entire island, the Gilbertese people in Solomon Islands were relocated into several distinct communities occupying areas of larger islands. So they weren't given this entire island. So there are some similarities and there are also some really big differences. And also their story is, the official reason given for relocation was environmental degradation, overpopulation of their islands. But many people, especially younger people, now wonder to what extent their relocation was linked to either nuclear testing, which of course was occurring on nearby islands, or also possibly a desire for phosphate on their islands. So the real reasons for their relocation are hotly debated, and there's a little bit written on that. Some of the work that I'm talking about today I've done with Dr. Tammy Tabe, who's produced the largest body of written work on the Gilbertese relocation, so I'd really suggest having a look at her work if it's interesting. But this is, so we did some work in communities together, but this is very much my thinking, which I am discussing with Tammy, but any errors or anything are most definitely my own. So I'm interested partly in thinking about how the Gilbertese relocation displacement was entangled with that of the Banabans. And it's also worth noting that Gilbertese people made up a fair amount of the workforce on Banaba, whereas Banabans were not employed to the same extent. I think that's correct. And this is also a common story in these relocations of British administrators employing people who on places that they don't originally belong to as a way of controlling that workforce. So I'm interested in this case in terms of thinking about how all these processes are related to each other. And in the time I've got, I want to focus in particular on what we might learn from the Gilbertese case about how understandings of land and property are entangled with understandings of belonging and citizenship. Or one of the threads of scholarship I draw on, and there's a colleague here who also does this work, is legal geographers often talk about law, place and people being brought into being together. And I think this really makes sense in a lot of Pacific systems where law, and by this I mean not just the rules and institutions of the state, but like custom and the stories we tell about land can't be, Katerina talked about how land and people can't be torn apart, and I don't think law can be torn apart from that either. So I'm trying to think through how these things keep reproducing each other. So I'm going to start by briefly introducing the tsunami in Western Province in 2007, the impact and the way the impact on Gilbertese communities there has been understood by outsiders. So I'm talking about the stories about land and belonging that have been told by aid agencies, donors, the international disaster response that came in. And there's lots of pieces of the puzzle I'll necessarily have to leave out. But what I want to focus on is how Gilbertese land rights have been understood by outsiders, and how this reproduces a vision of Solomon Islands that sees the problem as internal to Solomon Islands and the source of solutions as coming from outside. And I want to suggest that the real problem is the racialised system of land control that was established by the British and which is constantly reproduced in donor discourses today, and which maintains the sense of material and epistemological insecurity that the Gilbertese have. So at around 7:30 a.m. on 2nd of April, do I use this? 2007. So this is some images here. You can see the relocation from what is now Kiribati to Solomon Islands, and people were relocated to Gizo, to the Shortlands, and also to Wagina in Choiseul. So at around 7:30, on 2nd of April 2007, an earthquake measuring 8.1 on the Richter scale occurred about 50 kilometres south of Gizo Island in the Western Solomon Islands. And within minutes, a series of huge waves, measuring between about 5 and 9 metres, depending on where you were in Western Province, hit islands across Western Province and Choiseul, and they dragged trees, homes, canoes, and sometimes people out to sea. The most severely affected areas were the Gilbertese villages of Sisiana and New Munra on Gizo, and the tsunami destroyed almost every single built structure in these villages. And each time I've visited these villages, I've heard really harrowing stories from people who were swept out in the water, and they'll tell stories of what they clung to and how they how they hung onto trees and climbed up the hills afterwards. And some people have stories about how their babies and their children were wrenched from their grasp. A total of 52 people were killed across the Western Islands, but of these, 33 were from Gizo Island, and of those, 32 were Gilbertese people. The people who survived fled into the hills, where they set up temporary settlements, generally on land that was held by the provincial or national governments. They often went to areas where they'd had gardens for many years, and by 2016, some people had returned to the coastal areas, but many had also established fairly permanent-looking settlements in the hills. There's been a number of attempts to evict people, including the dispute went all the way to the High Court. I won't tell that story today. But there's been a number of attempts to evict them, and so far the Gilbertese residents remain on their land. Now, the tsunami and the really different experiences of Gilbertese and Melanesian communities on Gizo has prompted a number of research projects, and they're kind of seen as like a paradigmatic case for us to look at to think about a climate-affected future now. So there's a lot of policy reports that mention this case. And Gilbertese communities on Gizo are often appearing in global policy reports as an example of sort of the lessons that might be learnt. And I've got a summary here. So on the right-hand side of the page, this is how it's summed up in a report produced by the Nansen Initiative. And on the left-hand side are the key points that I want to draw out about these discourses. So key features of the published accounts, particularly the policy reports on the tsunami, tell this story. They retell how most of Gizo is alienated Crown land, and they'll say it was wasteland when the British arrived and there was no one living there. That's something that we could contest. And they say when the Gilbertese people were relocated there during the colonial period, they were given titles to the land that was allocated to them. Now, these reports then go on to say, today there is a lack of clarity in those records. There's widespread recognition that the records of the Ministry of Lands are outdated. There's a number of reasons for this. Many Gilbertese people report that they don't feel like they're listened to when they go to the Ministry of Lands. They have trouble accessing the records or updating the records. And there's also allegations of corruption. When Gilbertese people were relocated, titles were normally issued to male household heads only. This was very common anywhere in the world for these schemes during this period. And the colonial administration left the question of administration to communities to decide themselves, which they probably should have done. But what it's meant was it's introduced another element of uncertainty, because now people are dying without wills, and there's debates as to whether it should be passed down the matrilineal line, the patrilineal line, what was said on the deathbed, that kind of thing. There's also widespread recognition that the land initially given to the Gilbertese is inadequate for the growing population. And some Gilbertese people disagree with the maps held by the government, which show a smaller amount of land on Gizo Island allocated to them than they would claim that they were given. When Gilbertese people have sought to access additional land, this might be disputed by the government on the basis that the land's needed for infrastructure. So this is a problem that is likely to be faced throughout the region, given the extent of customary land, and communities are understandably going to be reluctant to give up land. It's also disputed, so Gilbertese claims to additional land might also be disputed by other communities who are also have their own populations are growing, and they're also in search of additional land. So the published accounts consistently emphasise, first, that there's a lack of clarity as to land holding on Gizo. Second, the Gilbertese people are originally, this is the story told in the policy reports, not necessarily the story I would tell. So 1, they say the land records are uncertain. 2, the Gilbertese people are from Kiribati and they're ethnically distinct from the majority of the population. And 3, that it is these conditions that leave Gilbertese people more vulnerable and less resilient in the face of disaster. So I want to contest this. Because what this work does, so this particular policy story, what it does is it tells a story that says the problem with Gilbertese insecurity is basically that Solomon Islanders have inadequate land recording systems. It also reproduces this idea that it's customary tenure that is inherently a problem to be overcome. And it requires outside intervention and technical solutions to solve all of this. It fails to interrogate this idea of ethnic, linguistic and cultural difference. It takes as given that Gilbertese people are fundamentally different to other Solomon Islanders. And it invisibilises the legal, political and economic structures that are rendering Gilbertese vulnerable in the first place. So by this, I mean things like they ended up there in the first place because of colonial perceptions of their islands being too unsafe to stay in. And I think that has really important lessons for now. And also this idea of Gilbertese people being fundamentally distinct from other Solomon Islanders. This is a story that we heard told during the tensions as well. What does this mean? Gilbertese people, like these people intermarry, they have children together. I did have a picture here that I took out. They belong to churches together. And what this does is like reinforce this idea that these are fundamentally distinct groups of people that don't have anything in common. So I want to suggest that none of this is natural or inevitable. Gizo is a relatively small island and it's often portrayed in these policy reports as really remote. And as I said, the consistent story you hear is that it's wasteland, that there weren't people living there at colonisation. I won't go into this now because I don't have time, my time is up. But I want to suggest that we might instead approach Gizo as a very meaning-filled and spirit-filled place, because if you look at where Gizo is on the map, I can't get an arrow, but it was at the absolute heart of these really vibrant trading and other exchange routes throughout the Western Solomon Islands. And many of the Melanesians who live on Gizo today have stories about how their ancestors came there and stayed there prior to colonisation. So I'm going to leave it there, but in essence, I'm asking us to think about, I'll leave it there. I'm asking us to think about whether these disasters are really natural, whether these ethnic and racial differences are really natural, and what are the systems that are maintaining these stories and these perceptions of difference and people as being unable to get along and live together. Thank you.
Okay, thank you to Katerina, Ray and Rebecca. So in my presentation, I want to take up the invitation that I think you explicitly or impliedly gave to learn from the experiences of Banabans and the Gilbertese and other displaced peoples of the Pacific and consider what cross-border displacement means for constitutions. So to clarify, by constitutions, I do not mean just the written formal document. I mean the arrangements by which communities are governed. These may be written or unwritten, and they exist not only at the national level, but also in communities within nation states, and for displaced people across more than one nation state. So when people in my field of work, which is comparative constitutional law, think about climate change and constitutions, the focus is usually on how constitutions can promote efforts in climate change mitigation, using human rights, directive principles, provisions for land and natural resource management. In other words, the tendency is to focus on what constitutions might do to address climate change. But the other important question is what climate change will do to constitutions. And so this might be reflected in constitutional design, but it will also just happen as the world around constitutions changes. So cross-border mobility, as part of the wider phenomenon of globalisation, is already occurring and is already changing the way we think about constitutions, and climate mobility, including displacement, will drive further change. So in order to think about what these changes are, I've structured my presentation around three constitutional concepts: citizenship, representation, and self-government. And we've already heard from Ray on each of these three aspects as they play out in Banabans and Rabi. So to begin with citizenship. Citizenship was a really sensitive issue at the time of independence when many Pacific Island constitutions were made. The experiences of colonisation and appropriation of land in particular made Pacific countries very concerned about who to admit as citizens and who could own land. At the same time, the mobility of Pacific peoples meant that there were many cross-island connections, which with colonisation and then independence became cross-border connections. So for these reasons, constitutions in the region can be quite inclusive in how they define citizenship or membership of the state. So an example is the Solomon Islands Constitution of 1978, which provided that, of course, people born in the Solomon Islands were Solomon Islander, but they also said people born in the Solomon Islands with ancestors in Papua New Guinea or the New Hebrides, Vanuatu, would be citizens. And they also said that citizens of the UK and its colonies deemed to belong to the Solomon Islands because they had resided there could apply for citizenship. And so these categories would cover the Gilbertese in Gizo that Rebecca told us about. And from Rebecca's work, I also learned that the Gilbertese became the only non-Indigenous group capable of holding a perpetual interest in land in Solomon Islands. So in these kinds of examples, we see a new state defining citizenship in a way that accounts for people from outside. But what about citizenship looking forward for those people who will be relocated in the future and join an already established state and citizenry? So in the literature on climate change and citizenship, the focus of attention is often on dual citizenship, so that relocated people are both citizens of their home country from when they came and their host country that they are in now. So over the past few decades, dual citizenship has become increasingly common across the Pacific and across the world. However, at independence, countries that were otherwise reluctant to provide for dual citizenship nevertheless did so in response to cross-border mobility. And I think this might have been the case in Kiribati, where the constitution permits dual citizenship only for i-Kiribati people. And I think this was partly in recognition of the relocated Banaban people who moved from Kiribati to Fiji. The problem, though, for much of the time since independence to 2009 was that Fiji did not permit dual citizenship. So Banabans in Rabi had to choose between being Fijian or i-Kiribati citizens, and that of course had implications for their movement between their two countries and homes. So the point I think here, and Ray made this point as well, is that dual citizenship has to be reciprocal for it to be meaningful. So another option that's discussed is to grant rights that are usually associated with citizenship to certain non-citizens. Again, an example under the Kiribati Constitution is that anyone of i-Kiribati descent has the right to enter and reside in Kiribati. Although I've learned from Ray's work in the Citizenship Handbook that often immigration officials at the border don't quite understand this constitutional right. Okay. I want to suggest here, however, that citizenship pathways like dual citizenship and visas and rights of entries are really only a partial response to cross-border displacement. So the problem is that while citizenship is about membership of a community, when it comes to acquiring a new citizenship, which is called the process of naturalisation, it is in fact highly individualised and it's controlled by the state that's granting the citizenship. For example, under the Whālipeli Union Treaty, Tuvaluans now have a special visa pathway in Australia. This is not citizenship. You know, Australian citizenship still depends on an individual meeting certain criteria of residence, values, and similar things like that. So Tuvalu is not entitled to decide who is a Tuvaluan for the purposes of relocation to Australia. The treaty, in fact, obliges Tuvalu to ensure that there are robust controls over its own citizenship. This can be compared to the situation in the realms of New Zealand, at least in the past, where New Zealand citizenship law kind of picked up those who were entitled to reside in Tokelau and Niue as New Zealand citizenships. So at this point in time, it meant that, people of Tokelau and Niue had a say in who were membership of their communities, and that had implications for New Zealand citizenship. So I want to suggest that mobility with dignity, or a just cross-border relocation, requires something more than extending citizenship to individuals. It also requires recognition of a relocated people as a sovereign political community, with its own governance, including the ability to determine its own membership. So this is the first challenge for citizenship law and constitutional law. So I think citizenship is usually framed as a top-down power of the state. So it's for the state to determine who is and who is not entitled to citizenship. And this framing depends on a background assumption that there is one source of political authority, usually set out in the written constitution, that constructs and confers membership of the community. So decentralising decision-making about citizenship beyond the state might be part of the way in which constitutions have to change. It's not an easy thing for countries like Australia to change. Some of you will know about the High Court case of Love and Toms, which was about whether Indigenous nations could determine who were members of their nations for the purposes of defining who might be an alien under the Australian Constitution. The minority judges in that case were really, really concerned that, someone other than the state could then determine who might be a member of the Australian community. Okay. So a second constitutional challenge in response to cross-border displacement relates to representation and in particular the status of the diaspora in their home state. So this includes things like whether citizens who are outside the country can vote in elections, whether the diaspora is represented in government decision-making. And again, Banabans and Kiribati provide examples of constitutional possibilities. So there are 2 seats reserved in the Kiribati Parliament. One is elected by a Banabans constituency in Kiribati, the other is appointed by the Rabi Council in Fiji. And these 2 Banabans members of Parliament actually have a power of veto over changes to certain provisions of the Kiribati Constitution relating to Banabans. Often these kinds of questions focus on representation and participation by relocated peoples in the governance of their home state. But I would also say that what is equally important is participation and representation in the government of the state in which they are now settled and living, particularly because they're likely to be a minority and therefore outvoted by majority democratic decision-making, even when those decisions directly affect their rights and status. So this is another challenge for constitutions, which is admitting groups with special rights and representation into the state. And there are constitutional tools and mechanisms for this: reserved seats, consultation requirements, veto procedures. So I think it's not a lack of constitutional tools, but political will in the host state to use them that might be the bigger barrier. Okay, 2 minutes left. So the third and last concept I want to discuss is self-government. So we know, of course, and Rebecca explained this really nicely, that relocated peoples will join the citizenry of the new state and live as members of that state. They will live and work and be around other people. It's not that ethnicities are always to be separated. At the same time, cross-border displacement is not about the movement of people as individuals. It's about peoples, community, and potentially nations with their own cultural ties and governance structures. And these governance structures form the basis for self-government and sovereignty in their home country. And so a just relocation should recognise this and recognise this continuing sovereignty as a basis for self-government in other places. Again, there are many constitutional tools to recognise self-governing groups within a state. But they do need adequate protection and constitutional protection. And I think the story of Norfolk Island in Australia is a good example of why that's important. So, Norfolk Island is another example of a displaced peoples. People were moved from Pitcairn Island to Norfolk Island in 1856. Norfolk Islanders claim their own identity and sovereignty. And as an external territory of Australia, Norfolk Island was given a degree of self-government in 1979, which was then unilaterally taken away by the Australian government in 2015. So without specific constitutional protection, self-government just became a gift that was given and then taken away. So this is the third challenge to constitutions, making space and protecting space for self-government of peoples with their own sovereign identity and their own constitutions and laws and practices. So the challenge, I think, is constitutional pluralism, not just the recognition of different legal systems under the one constitution, but of different constitutional systems operating in the same place. So very briefly, 2 points to make in conclusion. Mobility with dignity is not just about individuals' access to a place, but about the maintenance of a people's, even a nation. And this requires more than opening up visas and citizenship pathways. It requires constitutions in both the home country and the new host country that provide for forms of representation, land rights, and self-government for the peoples that exist within a nation, or in the case of cross-border displacement, across several nations. Secondly, mobility with dignity then requires policy changes that shift attention from the individual to the collective, but this in turn requires disrupting assumptions about constitutions as singular, closed, and tightly linked to the one state and the one legal order. In other words, it requires constitutions to be genuine about pluralism. And we can learn a lot from Pacific constitutions which already accommodate pluralism, but this would require a significant shift in constitutional culture in places like Australia. So I think that we can learn a lot, not just from Banabans and the Gilbertese in Gizo, but from the Pacific generally, about how constitutions can adapt and ensure that cross-border displacement is as just and kind as it can be. Thank you.
Thank you very much. Yeah. Question time. We've got about 20 minutes, 25 minutes. There's 2 mic runners. Maybe I'll ask a question to Ray. There's a mic. All right. No, it's not judged. All right. My question to Ray was looking at the Fiji government has indicated its intention to reform the Banabans Resettlement Act, and I wanted you to, say a little bit more on where Rabi people sit within sort of the framework of Fiji. You were talking about how they sit under the Prime Minister's office and the challenges of engaging with the government in Fiji. I know the Rabi Council of Leaders supposed to be elected, but elections has been postponed for a very long time, and
Yeah, thank you. Thank you, Romites. So, in terms of Rabi Council of Leaders, the Banabans Settlement Act was set up as part of the Fiji Constitution to provide governance for the Banabans in Rabi, in Fiji. So the legitimate body for the implementation of this act was the Rabi Council of Leaders, and the act, the Prime Minister is the minister responsible under the office of the Prime Minister's office to look after these Banabans Settlement Neck. So in 2013, the Rabi Council of Leaders was dissolved. It was dissolved because of mismanagement issues that the council. So basically, the Banabans in Rabi, they elect 9 councillors from the 4 villages that they duplicated the same villages in Banabang in Rabi from Teaiwa, Uma, Tabiang, Bokonikai. They elect 8 councillors, and the 9th is the chairperson, and that person also automatically becomes, not automatically, but appoints the Rabi MP to fill the 2nd seat in Kiribati. So when the council was dissolved in 2013 because of mismanagement, they could not reinstate the council. They installed a Rabi administrator to govern the affairs, which basically gives him the powers of the elected councillors in his time as interim, giving so much power to that person that he can do basically anything that he wants to administer Rabi and Banabans. So it's also important to note that the Rabi Council of Leaders under the Chapter 9 of the Kiribati Constitution gives so much power to the Rabi Council of Leaders who are in Rabi to look after the affairs of Banabans, because back in 1975, the Rabi Council of Leaders shipped about 200 Banabans back to Banaba. So by provisions in the law in Kiribati, they had that power to also be that legitimate body to look after the affairs in Banabas. So it had dual role when it comes to politics, governance, and anything development. They have to return back to Rabi to consult majority of the landowners who are there, because those that were sent in 1975 to Banaba, they were just custodians of the land to look after the land while everyone else is in Rabi. And the condition was every 2 years they would come back and another 200 people would go back, but then that did not work out. And so what we have in Banaba right now is the population that left in 1975 that never came back. So with these arrangements and the issue of our council, which is the authority on the island, being dissolved for almost, over 10 years now, it has really caused a lot of issues, because with that Rabi administrator looking after 2 affairs, and like someone also mentioned earlier in the presentation, that when communities become economically struggling economically, and that was the case for us, because mismanagement really led us to the downfall of the governance of our island, because we could no longer afford to look after the island's development and the community needs. So now it's Banabans versus Banabans trying to remind the island. And that's the sad reality that we, the young generation in Rabi, have had to struggle to resist the resurfacing of the mind, because rightfully we wanted this consultation to come back to the landowners before any deals are being signed. And that was a case that we worked on. But that was really an issue because power was really sitting on one person. So in Rabi at this present time, while we have a council that's dissolved, we have the Rabi administrator, the executive director, and the judiciary, which is somewhat not independent because it's also funded and paid by the Fiji government through the Rabi Council of Leaders. So with that power sitting alone with the administrator, he does and calls decisions, making and signing blind deals, and that was part of some of the work. But it's really because the provisions within the Banabans Settlement Act that we have now has a lot of loopholes that needs a lot of repair to actually strengthen these laws so that we can go and re-elect our council. So we've been part of national dialogues in Fiji, which Romitesh invited us to, and we were part of many forums. We were at USP. We also raised that question to the Deputy Prime Minister and everyone that was there, because despite the fact that Fiji reviews its constitution, since the 1990, 1987, the Banabans Settlement Act remains untouched because there were provisions through the early arrangement with the British court system that anything to do or to safeguard these laws, it has to go back to the Privy Council in the UK. So what we have right now is that when there's mainstream change to many of the legislations in Fiji, that's happening. it's happening without the consultation of the Banabans and their Banaban Settlement Act. For example, I raised a question to the Permanent Secretary for Local Government. Now that the local governments in Fiji are going to election, what about the Banaban Rabi Council of Leaders? And they said, we are not, in our act, we are not responsible for your affairs. You have to be talking to Prime Minister. And we've done a lot of talking, and we were happy that our Prime Minister promised us 2 times to reinstate the Rabi Council of Leaders, but I guess it's just the work in process, or maybe just politics along the way. But I'm sure if we make a lot of noise to hold our leaders accountable, they surely will take a lot of more solid action. So we've been talking with a lot of people within the office of the Prime Minister. We've been making a lot of visits to the Prime Minister's office. We've been challenging court. Banaban Human Rights Defenders Network have had 6 High Court cases with our Rambi administrator. And you imagine this is happening, Banabans versus Banabans, from a person who should be looking after his population, entrusted with an interim condition under the law that he should be protecting his people. Now he's taking them to court because he doesn't like being challenged in when communities mobilize with the communities to stop the mining that that they wanted to start to fund the very unstable and not financially viable Rambi Council of Leaders, which is our case now, because we've been struggling for over the last 10 years with a lot of abuses and mismanagement of our Banaban Trust Fund. And I'm not ashamed to talk about this because this trust fund was supposed to provide governance and well-being for our communities. But when leaders come in, they are entitled to use it as if it was their father's money. And as a result, it takes generations and generations to fill the issues that surround poor management of public money that should be looking after the affairs of indigenous people or minority groups in the bigger. And I say that because, while we respect that we are not indigenous to Fiji, we are a minority. But I also believe that we had an infrastructure set up rightfully from the start, but there was no justice in that. But we were privileged because, unlike the Rotumans and the Kioans, we had a trust fund. And most of the abuses that went into something that could have looked after our affairs now was really because of the loopholes of this settlement act that we have.
Professor Katerina is answering. If there's any questions, please raise your hand. Eileen.
Just briefly to add to that, this idea that power can be held by one person is absolute nonsense from a Banaban perspective. And so this is why history and the past are important. The Rambi administrator is almost like the resident commissioner of colonial times, where a lot of power was held by one person, and a transformation within culture that vested that power in an individual, as opposed to the highly more consultative, gender balanced kind of system that used to exist on Banaba, where women, young people, everybody had a mechanism for participating, for speaking, for being included. And so when Banabans today might say, he's the guy, you have to listen to him, you need to be polite, all of this stuff. This is part of the colonial hangover, a very hierarchical, top-down kind of view of what it means to participate in things like good governance and society and how to look after ourselves. And so Banabans versus Banabans comes from this very, like a patriarchal system, a colonial system, which has now become indigenized by some people, so that now it shuts out lots of different voices for participation.
And it goes to the point.
Add something to that, Ramitesh. And this, in this sense, this is a region-wide story, because this is a kind of structure that is in the interests of capitalism. Because extractive industries, for example, don't want to deal with an entire community. That's impossible. It's much easier to deal with 1, 3, 5 people, and it's constantly reproduced through those processes.
Wanted to say something about self-government? No? Okay. We'll move to Dennis.
Thank you. This is not so much a question, but just based on my experience working on the Bougainville conflict. Just want to make few comments. Firstly, thank you so much for the presentations on cross-border displacement. But let us not also forget the fact that internal displacement is very dangerous. All of the 5 Melanesian countries in the Pacific had gone into conflict. Papua New Guinea, Fiji, Vanuatu, New Caledonia, you name it. Melanesian society as well as West Papua. And this is based on the displacement of colonialism and also displacement from their ancestral land to a different land. This just sort of sharing again that in Pacific, land is has got intimate relationship with Pacific Islanders. If the land is not right, land ownership is ripped, then there is conflict in the Pacific. Because it's in the land where the ancestral spirits are. It's in the land where the life is. It's in the land the economy is. And it's in the land the social structure is. If land ownership is destroyed, then there's displacement in every society. I also wanted to share the experience of, in the Pacific, my understanding is we have got 4 types of laws at play. The custom law, Christianity, the modern law, as well as, the conventions. And all of these laws, they sort of displace societies. Like, for example, in Christianity, the common message is about the tenet of love. With the tenet of love, there's destruction on resources, on land. There's also this, like example in Bougainville, we have utilized the freedom to choose, to vote for independence. That has not been granted. So, what type of right is that? So, in the Pacific, displacement started during the Black Bedding days. The war brought Bougainvilleans to Solomon Islands and, across. Before colonization, Pacific Islanders enjoyed trade. They knew who their relatives were in the next island. And that sort of, issues now related to cross-border displacement challenges, those were actually, handled by chiefs. So all I'm saying is, I think it's time we take ownership and responsibility on what has actually happened, and then we own up and see how best we can deal with this. Even in here, Aborigines are displaced, and still yet today they are complaining, like the Maoris. So this is something that is very important. I think the time is very limited. There should be more discussions on this because we are dealing with human beings. We are dealing with, persons who have got their own land, who have got resources. If we do not give them that ownership, that responsibility, then Pacific will continue to, live in conflict. Thank you.
Would anyone like to respond?
We agree.
We agree.
We agree.
There's a question.
Thank you, Ambassador Rabi, for your presentations. I guess I had a question open to all panelists. Rebecca, I really liked what you said around colonial ideas of habitability of our islands has played a role in Kiribati moving to the Solomon Islands. And I just wondered if you had any reflections around whether we're seeing legacies, colonial legacies of these ideas in contemporary discussions around climate mobility and the future of our islands as well. Thank you.
I absolutely do, and that's why it's so concerning, because as Katerina pointed out, we have to remember these histories so that the same mistakes are not constantly repeated. And I hear this erasure of history all the time whenever we hear people talking about people with no connection to the Pacific making what they feel is a progressive argument, but they're reproducing this idea of drowning islands, drowning people, needing external assistance, which it's an externally generated problem. So I'm not suggesting that outsiders don't have a role to play. But we need to know all our histories and all our complicities in this so that we can see how they continue to resonate.
Yeah, I totally agree. And it resonates with something I think it was Ken Cooper in one of the earlier panels said about some of the rationale for historical displacement has to do with the disposability of islands and islanders. Like, for the good of mankind, but particular mankind, not all mankind, right? Western, metropolitan, colonial nations, for their good, these islands don't matter and these peoples don't matter. So in order to argue something that's more morally palatable, you have to come up with things like, they're not going to last much longer on that land anyway. It's a bit rubbish. Or they only grow things in a wild and crazy way. There's no proper cultivation. Or, so playing up the negatives in order to rationalize the extraction. So now we're hearing that same thing in climate change, like, oh dear, well, it was all a bit difficult anyway, so they're going to have to move. And we have to be really, really, really careful about that. But, for example, how many Pacific Islanders today go to uni to study history? I'd really like to know. How popular is the discipline and the field of history for Pacific Islanders to study? It's gone down hugely from the 60s and the 70s when it was really important to know your history in order to move towards independence and, self-governance and all of that. Now, least popular subjects in the arts and the humanities. So that is another way in which Pacific people are not encouraged to actually go back, unpack, and deconstruct the past. As long as we can keep everyone studying super useful, employable stuff that's good for capitalism, good for labor mobility, good for urbanization, good for economics, good for the GDP, that prevents us also from actually delving into what's really going on and making sustained, long-term transformations and changes. So it's all about the here and the now, quick, move along, sense of urgency, versus the need for quite a slow, methodical, careful unpacking, critical inquiry and understanding of the past and the present and what that means for the future. So all choices and decisions, and this is where I think we should take accountability and responsibility, because those are choices that we as Pacific people can make for ourselves. Yes, I'm sure it would be great if we all became lawyers, practicing lawyers, got paid lots of money or something like that. But actually, what we need is much more diversity in terms of the different kinds of sets of competencies and knowledges, interests from art all the way through to history and technical things and unpacking of AI and technology and everything else that's happening in the Pacific. So I think that's part of the accountability and responsibility part for those of us who have opportunities for higher education, work in these spaces, etc. It's much bigger and broader than just, know your past and know where you're going. Like our ancestors made choices and mistakes, and so do we continue to do that in the present.
Just adding on to the point about history, I wonder how we might think about climate displacement, for example, if we know that, so there's history figures in multiple ways. One is like uncovering the history so we understand the stories that colonizers have told to make a resource. So in the case of Gizo, the story was told that it was wasteland, no one was there, no one had any claims, that makes it a place that can be taken, when in fact there are many stories about that place and many claims over that place. What kinds of possibilities for climate relocation open up once we understand it was situated within this vast network of people moving around all over the place and many people had overlapping claims to it? What kinds of possibilities for climate relocation open up when we remember that, for example, people within Solomon Islands were banned from visiting each other because they were told by colonisers that island is too dangerous for you to travel to. I mean, we can go to it in our British boats, but you're not allowed to go there despite visiting each other for centuries, if not thousands of years. Or what kinds of possibilities for relocation open up if we take Apelihau off as our Sea of Islands seriously? And we remember, as Anna said, that inter-island travel became cross-border travel with colonisation. So our histories can also help us contest those dominant stories that keep people trapped in places rather than attached to and nurturing and caring for place. But history can also open different possibilities for how we think about who we are, where we belong, and how we belong to that place.
Can I defend lawyers very briefly?
Easy target.
They're a very easy target, and I want to say not all lawyers. No, I want to make the point that, you know, we've heard about constitutional review happening, Bougainville, review of the Banabans Settlement Act, and, you know, there's no technical legal solutions that will help resolve the actual problems. You know, if you really want to review and reform those fundamental laws, you know, the Banabans Settlement Act is kind of constitutional in a way for Rabi. You need to look back at history and work out what you want it to be. There's no kind of, I can't come to you as a constitutional advisor and say, here, this is what you need. You know, that's something that you work out through the process of review. So I am agreeing with Katerina when I say history is really important, and it's an important part of constitutional law, because all these past experiences and past constitutional texts will always echo through to the present. That's all.
Any more questions? Aka? Aka is a fellow Banaban Rabi Islander who's doing something on climate mobilities. Oh, first here. Sorry.
Thank you, Eileen, and thank you, Romitesh, and thank you to our speakers this afternoon. Look, I love listening in on all these conversations because I'm also informing my research, and I'm trying to, I think I stand in the middle because we don't want to repeat history, but at the same time, how do we inform our pathway into a future that's secure for everyone? Just as the panelists know, but just for the audience, I'm doing a PhD project on climate adaptation that looks at migration with dignity, right, as an option. There are many options that looks at, number one, first building resilience on the ground where we come from, so making sure that our people remain where they are. That's a priority for us. Number two, where lives are affected and impacted because of climate change, and people want to move outside for jobs, and that's where my research in labor mobility looks into this. How do you, I would really seek your advice on how you see this, because it's, I can't move away from thinking of this as a form of resilience in itself. I'm very pro migration for the sense that it's also an option that people might have. It's their right to life, it's their right to dignity, it's their right to mobility. So we can't really deny that, right? But how does it sit in all this? And let me just share very quickly with you, because I'm not coming in this space with, you know, one eye closed. I think we're very much aware of all this contentious debate around spirituality. And this is something that's really grounding me in my research. When I went back to Kiribati and did my field work, everyone is saying, we prefer circular migration. We want to go and come back. And I had you understand, Kati, that I'm working on a canoe methodology, Teaiwa, and what really struck me is the fact that the art of building Teaiwa itself is not just to go out into the ocean to hunt for opportunities, right? that wa is built in such a way that it must always come back home. So I will keep that at the back of my head. But how do we build on this narrative that you guys are saying? Resilience means this is our history, this is how we want to challenge colonial structures. And challenging colonial structures means also embracing opportunities. I may not want to leave, but my children are drinking salt water at home. Do I want to give them that risk of, living with a second-class life? Please help me understand where we can sort of navigate, because I do acknowledge my past as a Banaban and as an i-Kiribati woman, but I also want to inform my future moving forward. But how do we embrace this rather than saying this is not good? We have to stop labor mobility. I'm saying no. I think there's a lot that needs to be done on labor mobility, and the number one solution is let's not think linearly through a one pathway. Why don't we build opportunities in our so-called blue Pacific Ocean? Create jobs and then stop people from going. But if we can't create these opportunities, why are we stopping them? I hope that makes sense, and I'll give it back to the panelists. Thank you.
Question? Another question, and then...
Thank you very much. My name is Rudy Lugula. I'm from Solomon Islands, and I just want to stress the importance of talking with the right people, the people that know the knowledge, yeah? Because Kiso was not an occupied land. It was sold. Everything, the reefs, the beaches, everything, the landowners sold it. And what you have in there, in the research that you do, is people coming in, pushing their own agenda, and not taking in the holistic approach to what is happening, and also ignoring the traditional systems that we have. In Wagner, the Gilbertese have been adopted into the tribe that own that island. And they are part and parcel of us. So I think it's also looking at the traditional systems of settling people, of accommodating people, of embracing each other's culture and tradition. There are other ways, like the previous speaker said. Look at the opportunities. Look at how culture and tradition can help you. Migration and resettlement is not a new thing in our culture and tradition. Thank you.
Thank you. I just have a question. In the context of global governance and international law, how effective is the influence of the UN agencies in this space in addressing these issues? As we know, most of the conventions sits within the UN agencies. So how effective has the UN agencies been involved in terms of the interpretations of these conventions? Have they been harmonized well with the policies at the local level to address this issue of displacement? Thank you.
I'll try and be brief and speak to the three comments and then hand it over. So in the case of Banaba, the Banabans have appealed to the UN at least once, particularly in the 1960s. And I don't know all the details around that, but I do know that if you're British, you did not get very far. If you were German or you were something else on the losing side of the war, then you had more opportunities, kind of like Nauru, who managed to get independence. But Banaba was literally handed to the Gilbert Islands and incorporated unwillingly into the new country of Kiribati. Banabans resisted that. They wanted independence, self-determination, and sovereignty. They occupied Banaba. There were fights and conflicts on the island for that independence and sovereignty, and it didn't work out for them. And Ray can say more about, the potential within the UN context. So thank you so much for that question. And then for the two comments before, I totally agree with you, Aka, actually. It's mobility on whose terms? I'm sorry, but the labour mobility schemes of Australia in particular are colonial, they're exploitative, and they're not on the terms of Pacific people. They're really, really bad, and they completely vibe with 19th century blackbirding. 100% no different. I'm not being dramatic. They're similar to that, and also to labour mobility in the plantation times, where people were moved around. You come and work on the plantation over here, and you could see the effects on families, on children, on kinship, when people were just moved all over the place for the wealth and the profits of the employers. So that's the part that I disagree with. For who, on whose terms, like who's really getting the benefits of the scheme? So my problem is with the scheme, who conceptualizes it, who comes up with it, and then apologizes for 5 years saying, oh dear, we should do better, shouldn't we? Oh dear, rather than doing it in a better, more of a partnership, properly consultative, in all aspects. Talk to women, talk to children, talk to villages, talk to families, really find out what the benefits are. And we spent a bit of time yesterday in a workshop that Anouk organized talking about the labour mobility schemes and the impacts back in the islands. So of course we should be mobile. We are mobile people. When have we never been mobile for 6,000, 10,000, 40,000 years? We're not meant to stay in one place. I completely agree with that. I think the current system is not controlled by Pacific people. And I don't have all the faith in our leaders either to support a scheme that is actually beneficial to people on the ground. But 100%, we should take opportunities.
You can be last. Do you want to go? Yep, yeah. Yeah, I wanted to just respond on the question about how effective the UN is in this space to address these issues. And so there are international conventions on statelessness and nationality and things like that. But I think what is sometimes, we see these international conventions that are made at the international level, but how do they come into effect? It's the states and it's governments at the local domestic level that have to implement them through their constitutions. So citizenship is a matter for states. Constitutional law is a matter for states. Very rarely will international law kind of intervene in these things. Human rights aside, a lot of this stuff is a bit hands-off for the UN. They say, well, this is a sovereign process for the state to determine. States can determine who they want to admit as citizens. And so I think the international legal system in this space runs out quite quickly, which is why I think constitutional law has to kind of come up and fill this gap. We can't just say, oh, the UN will sort it out, because it can't. Yeah, I'll just leave it there.
I want to respond to Ruth because she's one of the most knowledgeable people about land in Solomon Islands. So thank you for that comment, Ruth. And yes, I absolutely agree. And what I presented is part of a bigger paper where I'm trying to make that point, and I'm trying to show that I'm still working on these ideas and working out how to explain them. But these kinds of donor reports that came out, I see them as reproducing these colonial ideas that as you would be familiar with, saw the West as a place of headhunting and as a place of customary systems that were disorderly and disorganized and all the stereotypes bound up with that. And what we are seeing now is a reproduction of this idea that customary ways of doing things, like the forms of inclusion you refer to for Wagina, that system doesn't work, it's dysfunctional, it's not inclusive, and it's maybe even violent, and that the solution is the state legal system, which is equally constructed by outsiders as being kind of benevolent and caring and inherently inclusive and never violent. And so these stories that donors are telling about, the problem of the Gilbertese is that they have insecure rights to land because they're different and because people don't want to include them. I just don't think that's true at all. That's not what we see on the ground all of the time. But I'd love to talk to you about it further because, yeah, I see these ideas reproduced all the time and they serve outside interests, and they will ultimately mean that the donors continue to try and take charge of relocation and continue to try and take charge of Solomon Island land, places, forests, and yeah, the same story over and over again.
Yeah, and I think just the last maybe thoughts or what I wanted just to share before we end this panel. I was part of the Pacific Climate Mobility Framework for 3 years, from 2019, 2021, before it was launched in the Cook Islands. And I guess I also want to disclose my position, because being part of that process as a young person, advocating for climate change, advocating for some of the lessons learned from our history, and also informing some of my advocacy work around my social work experience while studying in New Zealand and serving our communities. It was a dilemma for me to really think about the different modalities that were being presented in that framework, because here I am, a climate change advocate, fighting for our people to stay home as the best option, but yet we are working with a futuristic framework that also will provide options for people, to give them the options and the right to move if they wish to do so, because it helps with. And it was a back and forth conversation and debate around, and as a young person, we were firm that our position was around staying in place and having options. To give options, and it's even worse when you work around some of the maybe the human rights angle around giving people the minimum guarantee for safety, because right now, as we all know, countries who are emitting carbon are not doing so well in this space, and loss and damage is already an issue at hand in low-lying atoll nations. Internal displacement is still something that our leaders are still working around. And so it was, the 3 years was really a very good experience, because we had to really learn as much as we can from our past experience, but going forward, I was trying not to limit myself to maybe decline a better or safest option for people whose life were not even born, but whose life may be controlled by the options that we leave for them moving forward, in terms of how do we develop our islands, how do we build resilience, and how do we protect our people when they move across the borders.
Levu, thank you very much for your time and your patience. I know we've chewed into the afternoon tea. Enjoy your afternoon, and thank you to the panel.